Hernandez Govan just left court, and let's just be honest, he got some bad news today. This shit is one of those from bad to worse scenarios. Pay attention real quick, because this is a longer video, but let's go. In the that's the west side of Tennessee, United States versus Hernandez Govan. Order affirming magistrate judge's detention, decision, and ordering defendant detained pending trial. Damn, man. Come on. Free my guy, bro. Free the bald head nut, man. Pursuant to criminal complaint, defendant was arrested after being charged with cyberstalking in violation of 18 U.S.C. 2261A2. ECF number 3. So that's when y'all had these little dockets and all that. That's the third document that they send, or case, however y'all want to say it. But y'all know what it looked like. A probable cause / detention hearing was held before magistrate judge on June 16, 2026. At the hearing, the government called 2 witnesses, the alleged victim in this matter, referred to as JJ, and FBI Special Agent Harry Bumgardner. If y'all know anything about a Bumgardner, man, god dang, shout out to the San Francisco Giants, but neither here nor there, who submitted the affidavit in support of the criminal complaint. Based on the testimony, evidence, and arguments of counsel, the magistrate judge found probable cause that defendant had committed cyberstalking as alleged in the criminal complaint. The magistrate judge also ordered defendant detained, finding that there was no condition or combination of conditions of release that would reasonably assure the safety of any other person in the community, specifically JJ, meaning the victim, to put on a hell of a show that say, nah, man, you can't come home. Leave that man in there. He got a fry. That's what they're saying. Now, before the court are defendant's motion for review of detention decision and motion for reconsideration and appeal of order of detention, appeal to the magistrate judge's detention order. So what's going to end up happening is we're going to hear certain things, and this is something that a lot of people will pick up on, and you'll start to notice how the courts operate because you at the Hood Lawyer channel. So I'm going to spruce y'all up on something. Once you go for bail / bond and all that shit and everything, you get a little preliminary of the facts and all this shit and everything. They don't really present the case. So if the judge say, you know what, that's cool enough, and the bond amount is good enough for you, all right, go ahead and go. But if the judge says no, and you say, man, I want to try this again, or you possibly say, we want this damn thing denied, sometimes, man, it gets way worse, and they present damn near the whole entire case to you, as we've seen in the mother flipping Gucci Mane robbery case. Hit the playlist at the end to see that video right there. But let's get into the second half of this shit. Roll it. So they go through the Bail Reform Act and all this stuff and everything, shit that we don't really care. We really want the background, all right? So following the facts are based on the testimony and evidence at the hearing before the magistrate judge, meaning today. JJ and defendant met through mutual friends in November 2025. Since that time, they have hung out no more than 3 to 4 times. On at least one occasion, JJ and defendant had intercourse. Oh, somebody did not tell me the truth on this. Okay. And that the encounter was recorded. JJ intended for that recording to remain private. She never intended for it to be made public. She never gave defendant permission to share that recording. So in June of 2026, the relationship between JJ and defendant quickly deteriorated after defendant asked JJ to get him a rental car and gave her approximately $500 for that purpose. When JJ was unable to get the rental car, defendant became upset. He called JJ and told her he was going to shoot up her house. Defendant also sent JJ a voice memo telling her, I'm going to show you the date, B. You want to play with me? B, you better be in England tonight. Playing with me, I'm finna show the whole mother effer. You gonna see the devil. I'm bigger than the devil. Man, God. I ain't gonna lie. You kind of sound like me. I'm about to rub off on, cuz that's exactly some shit I would say. During the phone call, defendant, with the shooting up the house part, nah, I would never say no shit like that. Hell nah. But defendant also told JJ that he was about to post a recording of an ex encounter between them on Facebook, and that would have struck his whole entire Facebook down. I doubt that highly because his Facebook is monetized. That would have been stupid as hell. But in text messages exchanged after that phone call, JJ asked defendant multiple times not to post the video and told him that she was not trying to keep the money and offered to return it to him. Defendant then told JJ, you can keep it, B, and you're going to need it. JJ asked, so you don't want your money? To which defendant responded, nope. In another series of text messages, JJ asked defendant again to not post the video and offered to let defendant use her car, which defendant rejected, telling her, F your car, ho. Because she tried to give you the money back and let you use her car? You tripping, Brody. Later, defendant says, I'm bigger than the devil, repeating part of his earlier memo. Defendant also made statements to JJ, including that he was surveilling her at home, telling her that he had some people in a Nissan at the entrance of her street and that they were waiting on her. Defendant also sent JJ text messages referencing the presence of police and the National Guard outside of JJ's home, again, indicating that he or others were watching her. And it goes on to say the text messages were published at the hearing before the magistrate judge, and screenshots of the messages were included in Special Agent Baumgartner's affidavit. So it says, again, indicating that he or others were watching her and her home. Defendant told JJ that National Guard can't watch your house all day. LOL. You lucky you ain't at home. I don't give a F. I don't give a F about no police, National Guard, or nothing. And show them this message. Well, nigga, apparently she did. Be careful what you ask for. JJ testified that defendant's threats made her fear for her life and her son's life. That neither she nor her son have been back to her house since defendant made the threats to her and her son. JJ testified that she is terrified defendant will hurt her or her son, even if defendant is detained. Defendant was released from custody on June 12th, Friday. Criminal complaint and arrest warrant were entered into this matter the same day, and the FBI arrested defendant on those charges in this matter before noon the next day, which we told y'all he got arrested at 11 a.m. by the feds the very next day. So that fight video was fake as shit. Now, here's where I'm going to show y'all where being biased and unbiased comes out of road. I'm cool with Hernandez Govan, so this part right here, y'all going to be like, oh, hell nah, Ceddy Nash. If she told these people that it was a Nissan outside and the National Guard was there and the police was there, why didn't they go scope out a Nissan if they believed that this threat was credible? To me, personally, if I'm scared for my life and they really believe that, and I say, hey, man, it's at a red Tahoe down the street waiting on me. You don't think that the police shouldn't go investigate that, shouldn't drive over there or anything like that? That's the part where I'm in my head going, did the police or the National Guard think that this shit was really that credible of a threat? And understand something. The National Guard is in Memphis like staph infection. You hear me? They ain't going nowhere. They've been there for going on 2 years now. So when y'all see the police pull up and National Guard, it's only backup. But here's where y'all gonna say, all right, Nash, you want bias. Nigga, you did this to yourself. Flat out. You can't sit here, make threats, and think shit is a game. The tone of it seemed like he really just talking shit and trying to big himself up. But it don't matter if it's jokes and all that because he put an LOL on that. Whoever and however somebody take your messages, that's on your ass. People always have to be careful of 1, how you talk to people, 2, how they perceive you, and 3, if you know what you look like to everybody else. You got to remember, bruh, you got accused of getting away with killing young Dolph. So why wouldn't somebody say, shit, he done got away with murder once? Shit, he trying to get away with it twice? That's the part where it's like, yeah, bruh, hell nah. But this is where y'all gonna be like, all right, Nash, that's fair. Did she say all of that shit and show messages, or this is something that she said and it's blurred and muddy between the lines? I don't know, but let's finish this out. Under 18 U.S.C. 3142G, when making a determination as to a defendant's detention pending trial, the judicial officer must decide whether there exists a condition or combination of conditions that will reasonably assure both the defendant's appearance at future proceedings and 2, the safety of any other person in the community. These 2 considerations are generally referred to as a defendant's risk of flight and dangerousness. The government must prove risk of flight by a preponderance of evidence, and it must also prove dangerous to any other person or the community by clear and convincing evidence. In making this decision, the court considers the following factors. 1, the nature and circumstances of the offense charged, the weight of the evidence against the person, the history and characteristics of the person, the nature of the seriousness and danger to any other person in the community that would be posed by the person's release. For these reasons set forth below, the government has presented clear and convincing evidence that no condition or combination of conditions will reasonably assure the safety of JJ and her son. So defendant must be detained pending trial on charges in this matter. And then it says the nature and circumstances of the offense charge are serious and involve threats of violence against JJ and her minor child. Defendant argues that the communications between the parties reflect the frustration of a victim attempting to recover funds rather than any intent to harass or harm. That is not accurate. Defendant repeatedly threatened violence against JJ, despite JJ's repeated offers to return the money. Defendant even responded to one such offer by JJ telling her, "You can keep it, bitch." Defendant also made it clear to JJ that he was surveilling her home in the presence of police and National Guard were not a deterrent for him. In short, the nature and circumstances of the offense are serious and do not indicate that defendant's threats were hollow or illusory. This factor weighs in favor of detention. Then it says the factor looks at the weight of the evidence of the dangerousness and all that shit. And they talk about all this stuff and they say, hey, he went ahead and threatened her ass multiple times against JJ. In addition, defendant underscores the seriousness of his threats by indicating, this is going to be crazy, whatever they say, that he or others at his direction were surveilling JJ and that the presence of law enforcement would not deter him from carrying out his threats. Defendant's history and characteristics. And this is what screws you over. Everybody who's ever been in trouble, pay clear and concise attention, because if you've been in trouble with the law before and you get in trouble with the law again, this is the type of shit that they screw you over with. Under this factor, the court is to consider defendant's character, physical and mental condition, family ties, employment, financial resources, length of residence in the community ties, past conduct, history relating to drug or alcohol abuse, criminal history, and record concerning appearance at court proceedings, which is kind of funny because he got a bond on this exact same shit in the state of Tennessee, but it's whatever. Defendant has strong ties to the community, has lived in Memphis his entire life. He has family that lives in Memphis with whom he has a good relationship. And members of defendant's family were present at the probable cause / detention hearing to show their support. Prior to his arrest, defendant lived with his fiance, with whom he shares 2 children. However, defendant has a lengthy criminal history, beginning when he was a juvenile with charges of assault, drug possession, and possession of firearm. And he also has numerous criminal convictions as an adult. These convictions include possession of controlled substances, assault and aggravated assault, and unlawful possession of firearms. Notably, defendant received suspended or probationary sentences for at least 5 of his prior adult convictions in state court. And each time his probation or suspended sentence was revoked. They saying this nigga don't listen to shit. In addition, defendant has 1 prior federal conviction. After serving 42 months incarceration in that case, he was placed on federal supervised release. Starting in December 2015, defendant violated the terms of his supervised release multiple times within the first year, with the first of those violations occurring in January 2016. Man, everybody I know that's bald head just don't listen to shit. Less than 2 months after his supervised release began, the violations eventually resulted in his release being revoked in 2017, at which he was sentenced to 60 months. You gotta be shitting me. What the heck, man, bruh? Hell nah. This is the one dude you can't play Simon Says with, because, nigga, he out on the first damn try. Finally, defendant's history includes repeated instances indicating alcohol and drug abuse, which, shit, that's actually a good thing, and I'll tell you why in a minute. Although the defendant has strong ties to the community and family support, he has repeatedly shown that he is unwilling or unable to comply with court-ordered conditions of probation or release. This pattern cannot be ignored. This factor strongly favors detention. Nature, seriousness of the danger to any person or the community. Defendant's release in this matter would pose a serious threat to the safety of JJ and her minor son. Defendant has repeatedly possessed firearms despite being a convicted felon, barred from possessing firearms. He has repeatedly violated court-ordered conditions for suspended sentences, probation, and supervised release. And based on his own words, he directed others to wait on JJ in a car near her home, and the presence of law enforcement would not deter him from acting on his threats. Defendant poses a real and serious danger to JJ's health and safety, which could not be mitigated by reconstructed conditions on release. This final factor also weighs in favor of detention. And so, as explained above, the government has shown clear and convincing evidence that there is no condition or combination of conditions that will reasonably assure the safety of JJ and her minor son. Accordingly, the magistrate judge correctly found that pretrial detention is required, and that decision is affirmed and ordered that defendant remain detained pending trial in this matter. It is so ordered this 16th day of July, 2026. Mark S. Norris. All right. Notice how they put the drug or alcohol abuse shit. That's basically because, they smoke Bama in Memphis. So them is failed ass drug test right there. That's the only way they can prove that, because you would have to have a goddamn rehabilitation home or something like that or anything like that. So, hey, it is what it is on that part. But, yeah, ugly shit going on. And once again, I don't think that this is some shit for the feds. But once again, you make that damn threat when the National Guard is there, you out your goddamn mind. It is what it is. So as far as Quet go, man, listen, you gotta hold on your composure, bro. You getting paid too much for these goddamn interviews to be tripping off for $500. Shit, do some baller shit next time and sue a bitch. That'll treat them different. Show in there with a goddamn vest looking like a goddamn reverend from Sundays in Tennessee. Like the cussing pastor, R.I.P. to him. But on a serious note, man, we will see what will happen. That's how they play. When the feds say, hey, you want to try to get that bond reduced or get another chance at bond, we're going to come with the booyah. So that's the whole case right there. But I would ask y'all this simple question. What the hell do y'all think is going to happen? Do you think the gavel going to slam and he going to be found guilty? Or y'all going to say, you know what, bro? The fact that the state still has the case, they might be able to argue that this is a state case and ain't shit about this federal. But once you use that phone, automatically the feds can come in and tap dance with anything. And that's the part where a lot of cats need to understand law. I know people want to say certain here's and there's and all that shit. And his lawyers are going to have to argue this as a state case so that he'll possibly get goddamn probation in the state and get a tap on the hand and a no-no and all this shit. But once you use the phone, it becomes federal. I don't give a damn who tell you what. Any lawyer worth their salt will tell you. Phones equal federal. Get some goddamn burner phones. I'm joking. Don't do any of that shit. Stay in school, kids. Don't. Somebody get over on you, bruh. At the end of the day, before you did what you did, meaning before you went ahead and indulged with them, think of the worst thing that could happen and then make your decision if it's worth it and how you would react if it didn't go your way. But subscribe, turn on the bell to notify, share to keep y'all people aware. Click right here, though, to see how JD Vance gets spanked by the visionary. Y'all might like this new shit. Click right here for that video or click right here for the playlist. And once again, if we get it rolling with the JD Vance shit, we'll squeeze a little bit into politics every single day so that we still on the bunk and bullshit, but we on that political stuff too. So click right there for that video or click right for the playlist, and I will catch y'all in the next one.